This too is not only rise. Well, that's never been true. Custom can arise even with one incident. When the first artificial satellite went around the world, the question was, does it belong to is it trespassing the airspace of the countries below it, or is it involved in a new freedom zone? And the answer was immediate, that the artificial satellites, traveled in the stratosphere, not in the atmosphere. So that when the early views were that a nation has jurisdiction over its territory as far high as you want to go, they've now put a customary law. Hello, I'm Anthony D'Amato. This is the second lecture on sources of international law, where we're going to focus particularly on what is called international customary law. To begin with, the word custom can be very misleading. Some people say that it takes a long time before you have a rule of custom. It takes many iterations of practice before a rule of custom can arise. Well, that's never been true. Custom can arise even with one incident. When the first artificial satellite went around the world, the question was, does it belong to is it trespassing the airspace of the countries below it, or is it involved in a new freedom zone? And the answer was immediate, that the artificial satellites, traveled in the stratosphere, not in the atmosphere. So that when the early views were that a nation has jurisdiction over its territory as far high as you want to go, they've now put a cap on it. 5 miles or so is what you get. Beyond that is the range for artificial satellites. And that happened immediately. So things can happen right away. When President Bush a few years ago declared that there should be no safe haven for terrorists, a new rule of custom was declared and established overnight. Every nation realized that if a state, any given state, were to harbor a group of terrorists and not remove them or not make it impossible for them to be there, then other states could come in and destroy by air attack that camp of terrorists. An amazing new customary rule established almost immediately. Sometimes people say that to find a rule of custom you have to find the opinio juris, that is, the mindset of the nations. It is said that a rule is not a rule of customary international law until it is accepted as a rule of customary international law by the states. This too is not only misleading and wrong, but it's illogical. How can a rule arise when it has to be accepted by states before it has arisen? How can acceptance by states be a condition for the establishment of a rule? Well, unless you have a rule, the states are not going to recognize it as a rule. So there's no way of separating the idea of opinio juris from the rule itself. The idea of opinio juris indeed would suggest that you go around and interview various state officials and say, well, as to this alleged rule, do you feel that it's binding on your country? Is that a feeling that you have? Even if they were to answer you in a silly kind of exercise as that, you don't know whether they're telling the truth. They might say it's not binding on us because that's a rule that the country itself doesn't want to have to deal with. So the whole idea of having a subjective intent to follow a rule in order for that to be a rule of custom wipes out. It's just cancels out. There's no way of There's no method to get at those rules. Where do rules of customary international law, therefore, come from a different source? They come mainly from treaties. And now the question we're going to ask is, why do rules of international law come from of customary law come from treaties? How does that process occur? And this gets us back to a very elementary part of international law, probably the most elementary beginning step that you can imagine. And that is, there would be no international law unless there were disputes. States, if they simply got along with all other states, wouldn't need rules of law to tell them how to get along with other states. They would simply do so. Rules are necessary when states get into disputes. Let's call a dispute between two states a controversy. I like that word because the Constitution of the United States refers to cases and controversies. And under United States constitutional law, the word cases is all we ever needed. The word controversies is hardly ever used because it means the same thing as a case. But in international law, which the framers may have had in mind when they used this term, in international law you can have a controversy between two countries, but not a case because there's no judiciary waiting to take jurisdiction over that case. It has to be resolved by the states that are engaged in the controversy itself. Now, how are controversies between states resolved then? Because it's the resolution of the controversies that are really interesting and not just the fact of a controversy. One way they're resolved is by the states going to war. Well, if that happens, we can probably say that there is no precedent established for international customary law because states simply went to war, and war from a point of view of international law is anarchy. It's just the absence of rules, at least it was in the early days. But when disputes get resolved, no matter how they get resolved, the resolution of this conflict, the resolution of the dispute, the resolution of the controversy, whatever that is, becomes very significant from the point of international law. If you look at international law as a new child coming into the world and not having any particular notion of rules or behavior, that child begins to pick up these notions when a rule is applied to the child. And pretty soon the child begins to understand that in a situation where the child may be disagreeing with its parent, but a rule is applied, then that rule becomes determinative of that controversy, you might say, that the child was having with the parent. When two states resolve a controversy, then the resolution of that controversy becomes very significant as a precedent for customary international law. One way to look at this, and this is not complicated, it's very simple because the analogy to it is in common law. Back in the 11th century, when there were no legislatures and disputes among citizens were resolved by going to a court, where did the court get its law from? Well, it got its law from the previous resolution of similar disputes. The court in the 11th century says that law goes back farther than the mind of memory, than the memory of man has to the contrary. Law is eternally present from all the way back, and there's no beginning to it. Common law always existed. But the specification of common law, that is, the rules that come out of common law, are the rules of dispute settlements. Well, what are those dispute settlements under common law? They're nothing but the decisions of courts. When a court makes a decision in a common law case and gives the award, say, to the plaintiff, the dispute is resolved, and we know from then on that in a dispute like that, the rule that enabled the plaintiff to win becomes a rule that is honored by future courts as a precedent. So common law grows by the increasing number of resolutions of disputes in courts. It's the case results that count in common law and not everything else. The result is the most important thing because it establishes peace. It establishes stability between the parties. In international law, we take out the judicial overlay of this view, but at the same time we look at the fundamentals, and the fundamentals are the two states eventually resolve their disputes or go into an interminable war with each other. Wars are very infrequent. If you look at the history of states, as I did when I made a survey of this, a statistical survey, I found that in the average life of a state, only 2% of its time is engaged in war, any kind of war. 98% of its time is peaceful. So that peace has an overwhelming preference to war in historical terms, even if we just take the average figures of the number of years that a state is engaged in war, divided by the life of that nation. So the international law, customary international law, we might say, therefore, is peace-oriented. It's trying to achieve a kind of peace. It's trying to achieve stability among states. It's trying to avoid war. And that's the same thing in common law. Judges try to make decisions that will not lead to further fights and revolts on the part of the dissatisfied parties, but rather both parties will go out of court, one, of course, winning, but the losing party thinking, well, after all, that was the law, and I'm beginning to realize now that I had no right to that decision because my position was contrary to the law. So when states, getting back to states under international law, do the same thing, they resolve their disputes, the resolution of those disputes counts as a kind of precedent. And what is that precedent? It's nothing more than customary international law. The custom that has evolved over the years of the experiences of dispute resolution. Because of the importance of peace to any legal system, in fact, vital importance, because a legal system can only exist in a situation of peace. In war situations, it becomes the legal system itself is jeopardized because of the anarchy that war brings into the picture. The direction of international law, therefore, is in the direction of peace and stability. There's always a bias in favor of that. So if you have a dispute, a controversy between nations A and B, and A's position, as you look at it, would probably lead to further friction between the two countries, and friction between other countries that may be in the position of these two countries. Whereas B's position leads to settlement, peace, and stability. International law will tip toward the B's position. It will say that B is more likely to be articulating the best rule of international law because the outcome is a peaceful one. That, I would suggest, is true in every negotiation, in every judicial decision having to do with international law, that there is a bias in favor of peace. Now, there's a second bias, and that's in favor of cooperation. That states not only thrive in a peace environment, but they also thrive in a cooperative environment. Their wealth is maximized by international trade. International trade brings wealth to the countries because it gives you products that are cheaper than the ones that you could build yourself, and at the same time gives you an outlet to sell the products that you most efficiently can create to countries where it is too expensive to create those products. So the exchange of the produce, the products of work, industrialization, service, whatever kinds of work you're talking about, increases the wealth of a state. two people engaging in a state, the wealth of both of them increase. It's not a zero-sum game. So international cooperation, being that important to the maximization of wealth and the well-being of states, is, I'd say, at least almost as important as the achievement of international peace. We have peace, we have cooperation as two goals. And when you're looking at a dispute with respect to what is the rule of common law here, and there are some candidates for that rule, the one that you choose will be the one that tips toward peace and cooperation. You can look at that rule and say, if every state did that, things would settle down. Whereas if every state did a different rule that's being alleged to be a rule of custom, but falsely, as it turns out, then that rule should not be accepted as a rule of customary international law. So what I've suggested comes back to what I said in the previous lecture, that international law is a tight system, that you can always find an answer, and when you introduce the normative decision-making of states of custom that tends toward peace and tends toward cooperation, that will tip the scale in favor of those rules that bring about that state, and in those rules then becoming the precedents for future rules. So customary international law has led to a tremendous amount of peace in the world, one that would not have been predicted by, say, an anthropologist looking at human nature 4,000 years ago. They would see fighting and greed and corruption and attempts to steal other people's property and goods and spouses, all of those things that are part of the human emotional condition. It would be strange if that person were to predict that 98% of the time the nations in the world are going to be at peace. And if we come this down to the present day, the figure is even higher than 98%. There hasn't been an external war, that is a transboundary war, since World War II, except for Saddam Hussein's attack on Kuwait in 1990. The one exception that proves the rule in a way, that transboundary wars have almost are now archaic. They are not part of the scene. We have many internal wars that have flared up, the internal in Yugoslavia, in Vietnam, North and South Korean wars, many of the wars in Africa. But external wars of conquest since 1945 are notable by their absence. And this, I think, will ratchet up the percentage that I was talking about earlier, that instead of 98%, we may be getting close to 99% when enough time goes by, that nations are at peace rather than at war. This incremental increase in the peace component of international law, I think, is attributable to the fact that international law selects those decisions, those conflict resolutions that contribute to peace. It's a self-fulfilling prophecy. If you have a legal system that tips toward peace and interchange and interaction of states, then peace and interchange and interaction will become favored over time. Those of you who are evolutionists will see what I'm talking a lot about, Darwin's theory of evolution, that those mutations that are successful become the animals and plants that we see today. In international law, those conflict resolutions that are successful stabilize the system that we see today, so that we have a system that's full of rules, full of dispute resolving mechanisms, in a much more nuanced and specific way than they ever were in the past, because of the citation of prior examples feeding into and making more specific and latticed, you might say, the present rules of international law. So the future looks pretty good, unless something shatters the whole thing, like nuclear weapons, and that's something that is external and a violent possibility that could destroy us all. But otherwise, I think international law, left to its own devices, will increase the amount of peace and interchange in the world, simply because that's most conducive to the increase of international law. The two things work symbiotically, one might say, and give us, therefore, a good insight into how to resolve questions of what the rule of international law is. The rule of international law is most likely to be that one which contributes to the peace and interaction of states, as opposed to a rule that could lead to further friction. No matter how right that second rule may seem, in terms of just strict legality, customary international law is not trying to establish a system of precise legal articulated rules. Rather, it's trying to find those rules that will be most conducive to the further expansion and influence of international law itself. So the system of international law, therefore, tries to ensure its own future by changing its environment, that is, changing the world to be more conducive to rule acceptance. In addition to treaties and custom, as I said in lecture number 1, there are other sources of international law delineated in Article 38 of the Statute of the International Court. And so for the remainder of this second lecture, let me pick up and discuss those additional sources. One may never have to get to those additional sources. Customary international law should work in any international dispute. But assuming that nations want to say a little bit more about the subject, they want to go a little deeper, they want to find some other rules, they can look at these other sources. General principles of international law. What's a general principle? That term is used all the time. A general principle of international law is an extrapolation of the practices of countries within their own territories, where international law would not normally be applicable. International law talks about the relations of states to one another, but within the state, internally, there may be rules that grow up that are part of the law, but do never really become part of international law between states. Specifically, rules of civil and criminal procedure. The rule that you are entitled to a hearing before a magistrate once you're arrested, the rule of habeas corpus, also called amparo in many other countries. That rule that you must see a magistrate is not a rule of international law, because it doesn't involve nations. It involves people within nations. But if an international court is set up, then suddenly that principle becomes applicable again. In the Southwest Africa cases, for example, that was decided by the International Court of Justice, the question came up whether the court had subject matter jurisdiction over the case. Subject matter jurisdiction. Well, subject matter jurisdiction has never been an issue, or has never even come up in relations between nations. If nations have a dispute, international law applies to the resolution of that dispute, pure and simple. But in courts, sometimes a court's jurisdiction is prevented by a lack of jurisdiction over the subject matter of the dispute. Well, the International Court of Justice accepted that general principle about jurisdiction over the subject matter, and they threw the case out. Ethiopia and Liberia were suing Southwest Africa over the apartheid situation, and the International Court of Justice ducked the issue by saying there was the lack of subject matter jurisdiction. That's what general principles might do, and I don't think that it's worth going into in great depth, because it's not likely to come up in the dispute situations that I began these lectures by saying that the rules we're going to be talking about will apply to international disputes. Next, subject to the provisions of Article 59, which are simply provisions that have to do with the precedent value of a case and not important. Judicial decisions and the teachings of the most highly qualified publicists of the various nations as a subsidiary means for the determination of the rules of law. When I was in college and I read this, I said, oh, I want to be an international publicist, because my work may actually become part of the law. That if courts are going to look at the work of highly qualified publicists, then all I have to do is become a highly qualified publicist, and what I say may actually have a bearing on the rules that courts will apply. That's not too far from the truth. The writings of publicists are very different in international law than they are in local law. In the United States law, for example, we have Williston on contracts, Corbin on contracts, Prosser on torts, Wigmore on evidence. These are the scholars who have written the best treatises on those particular subjects. But if you look at Wigmore on evidence, the worth of what Wigmore says is 100% determined by the cases he cites. If those cases support the theory in the text, then the text can be used as a shorthand to encapsulate the results of those cases. But what Wigmore himself believes, as opposed to what the case law says, is irrelevant from the point of view of American law. And I think that's probably true in most countries. The person who writes a treatise is simply gathering judicial decision-making and putting it into a coherent form, but is not himself or herself adding to the content. International law is different. International law, at least in the early days, was thought to be pretty sparse, that there weren't too many rules of custom. The things I've been talking about in this lecture were not really foremost in people's minds 100 or 200 years ago. But they looked at treatise writers, people who wrote treatises on international law, and said, maybe these people really know what the best rule is. Maybe what they say in their text can be a decision-making rule. Why would they know what was best? Because of the peculiar nature of scholarship, that one must give a credence to both sides of the argument and write about a rule as if it is a neutral principle. Scholars gravitate toward that. They want to say, well, this is the rule because most nations use it, and because it's a neutrally on its face does not give particular push or weight to any one nation. So the international courts, when they look at the writings of publicists, as in the case of West Rand Gold Mining Company versus the King, the British court said, we'll look at the writings of publicists because those writings tend to be neutral. They tend to get at the spirit of customary international law in a way that it would be very difficult for the court to emulate. Well, that's interesting stuff. I find it interesting because, as I say, for a while I thought I might even make a difference. But at least it's there, and I just wanted to mention what it's all about. These subsidiary rules are not tremendously important, nor is the second part of Article 38 that says, this provision shall not prejudice the power of the court to decide cases ex aequo e bono if the parties agree. Well, that's a big nothing in a way, because it says if the parties want to decide the case on purely equitable grounds, if that's what they want, the court is perfectly willing to satisfy them on that. It makes the court from a rule of a dispenser of international law to an arbitrator, but that's okay if disputes can get resolved. International law is not interested in the future of courts. It's not interested in legislatures. It's not interested in executives. It's interested in peace. It's trying to promote stability and order in the world so that people can live their lives without the fear of being caught up in a horrible war. And this notion of peace is what drives international law, and not particular institutions like courts. So the Article 38, which is written as a part of the statute of the International Court of Justice, is not the same. The goals of the court, laudable though they may be, are not exactly the same as the international law that the court should be applying. So that just about concludes what the texts tell us the sources of international law are. And in the next lecture, I want to talk about human rights and enforcement of international law.